Hi YouTube, this is VidHead85 coming at you with I just read a post on Facebook about the Illinois marriage law being challenged that defines marriage as a legal union only between heterosexual couples, and also one in Nevada. The same one is being passed as well, or is being challenged there as well. I believe there was a vote, two different votes, one in 2000 and one in 2002, which the first one was probably a statute, the second one was more than likely the amendment to follow. The Cook County registrars or executive, the people who keep the marriage licenses, they're not defending the law either. And we've seen this with Obama not defending DOMA. We've seen this with Governor Abercrombie of Hawaii also not defending its DOMA. We have seen this now with Illinois, and I don't know if anyone who's defending the Nevada one. But this is an interesting thing because of the fact that even though now there is no they're not defending the law, that does not mean that a third party cannot step in, as we've seen with the Proposition 8 case. But it is a turning point because of the fact that when they take the oath to uphold the state constitution, a lot of times the religious right says, well, the Constitution says that marriage is between a man and a woman, you must uphold that. Well, you must uphold it within the spirit and context of that state's constitution, and by that state's constitution, it is unconstitutional. So therefore, it cannot be defended, and it should not be upheld simply because it treats one group of citizens differently from another. But I really like the fact that so many other officials have not defended those unfair laws because it is gaining momentum. The struggle for equal rights is gaining momentum, and they are soon, I believe, we may very well see marriage in Illinois and Nevada, but we're going to see it sweeping all across the nation one of these days, whether it be the Prop 8 case or a case after that. So another point about not defending the law is sometimes people may feel as if, well, if the elected officials aren't doing it, then they shouldn't be in that position. This is not the first time that someone has chosen not to defend a law, especially with Obama and DOMA. We had Reagan not defending a law, and the Supreme Court sided with him. We see also there was Woodrow Wilson, Bush the first, Bush the second, Clinton, Carter. All of those presidents have chosen not to defend a law, and it was defended anyway without the executive branch defending that law. So now people believe that the elected officials aren't doing their job, but it is at their discretion whether or not they will defend a law. They are charged with defending the laws, but again, someone else can do that if they are granted standing by the court. So those are my thoughts on that a little bit. I want to just briefly mention the whole California thing. With Prop 8, I felt as if the proponents shouldn't have been granted standing on one issue, is that they were not personally harmed by that verdict being rendered. But the other thing was it would create an unaccountable group of people who have money backing them. On the other hand, the voice of those millions of Californians would have been ultimately vetoed because of the fact that the governor did not defend that law. So in that way, I can understand granting them standing. However, I felt that they shouldn't have been, yet reluctantly I agreed with the California Supreme Court on that because of the fact that it needed to go through its scrutiny. It needed to go through the judicial wrangling necessary to strike it down eventually. So what are your thoughts on the Illinois and Nevada cases, and what do you think will happen with the Prop 8 case? Should they grant certiorari or simply say, I'll hear the case? All right, see you later, YouTube.